in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much.
It's that classic DuhRel Brooks Jr. victim mentality, rush to judgment, poor me, I'm the victim, it's all about me. It's all about the pain, it's all about me and the people that I love. It's about the inconvenience to me and the people that I love. It's not about the victims. It's not about the 6 people that he killed. It's not about the dozens that he injured. It's not about the community he wreaks havoc on. What's going on, everyone? This is Christian Duke. You're watching Sight Sounds Flavors on YouTube, sightsoundsflavors.com. If at any point during this video you like it, give it a thumbs up or smash the like button, as some of you hate. Also, I gave Judge Joro 97%. And what else was I going to say? Yeah, share the video, subscribe, ring the bell for notifications. Most importantly of all, leave a comment down below. So, you know, we heard rush to judgment. We heard tacit agreement or whatever he said. We heard, you know, about the coaching allegations that the prosecution had been coaching the witnesses, which is absolutely ridiculous. But why did we hear about this? Because DuhRel Brooks Jr., you know, in his sovereign citizen mumbo jumbo, was convinced that an injustice was afoot. He was convinced that the jury view of the SUV, the opening of the door, which he never understood, the questions that were sustained or the objections that were sustained, how his objections were largely overruled. He never understood because he wasn't a lawyer. I mean, you know what I mean? I'm not going to go down to the GM plant, which actually is not a good example because UAW's on strike, but I'm not going to go down to the Toyota plant and try to work the line or build an engine or assemble a seat or assemble an airbag when I have no training. You know what I mean? And I don't expect to just learn that, you know, in a crash course of 50 or 60 minutes or whatever. That's a career, you know what I mean? And people get really good at that career. And you want someone that's really good building your car. Because God forbid you ever get into an accident, you want the seatbelts to work, you want the airbag to deploy, you don't want the car to like crumble, you know what I mean? And so that's what this guy didn't understand. And that's why the judge admonished him as much as she did, because, you know, when he gave up counsel, he basically, you know, he sealed his own fate. Not to mention the fact that he was guilty of sin, had no remorse, and is a very hateable, you know how there's that term likable? I don't know if hateable is a word, but if hateable was a word, DuhRel Brooks Jr. is a very hateable person. I mean, you know, you take a totality of the circumstances, you take, you know, his antics of crossing his arms, looking up at the ceiling, nodding his head, yelling, staring people down, coupled with the lack of remorse, coupled with the narcissism, and you have a hateable kind of guy. He's a hateable kind of guy who does not know the law. And so when he decided to represent himself, and then on top of that, whoever, you know, gave him all his sovereign citizen crap, which actually carried over into the appeals, because the first day of the appeals, he was still spouting that sovereign citizen crap, did him no favors. But the judge wanted to make sure that, you know, what was to come didn't come, because exactly is what happened. Exactly is what happened. Man, that's really good English, isn't it? But the thing is, everything he complained about, and how many times did the judge have to say, listen, if you're asking me how to do something legally, I can't do that. She's not allowed to do that as a judge. But you're the referee, you're the umpire. Yeah, okay, and that's another thing she shouldn't have said, because it came back to haunt her. Came back to haunt her. You know, she tried to use an analogy of what her position was as a judge, an impartial person presiding over two sides, the defense and the prosecution, and making sure that as a referee or the umpire, that whatever came in for the jury to hear was fit for the jury to hear. He didn't, you know, he just got stuck at referee umpire. And maybe, you know, where he played ball, if he played ball, or he played another sport, maybe he was a chess player, the referee was partial to him. And so he saw a referee, a good referee, as being partial to him. But, you know, the reality of the matter is, you know, for all of his complaining about not understanding, Your Honor, how can you proceed if I don't understand? I mean, I'm just asking you to explain it to me. It seems reasonable, right? But it's not, because that's the job of an attorney to do, to explain to the client. Because attorneys go to school, unless you're in California. In California, you can actually sit for the bar, I believe. I may be mistaken, without going to law school. But you still have to know the law, otherwise you wouldn't be able to pass the bar exam, right? So wherever you learn it, you have to know it. And he didn't know it. And the bottom line is that him asking just to be explained what is going on seems to be reasonable in any other setting but that one. Because in that setting, you either have a lawyer or you are a lawyer, but you don't get to get a law school education from a judge, because that would otherwise be known as obstructing the process, delaying the process. Whether or not you really don't understand or not, I said not twice, it still delays the process. It's still a disservice to the people. And in this case, the state of Wisconsin. Where is the plaintiff? You are seeing the plaintiff as represented by the prosecution. They represent the state of Wisconsin. They are the plaintiff in this case, okay? But it's not a plaintiff per se, because it's a criminal case. It's not a civil case. The people, are prosecuting you. The government is prosecuting you, okay? And that's something else that he didn't understand. And he didn't understand it. But then again, a lot of sovereign citizens don't understand it because they don't realize that what they're spouting is a bunch of nonsense, And you see them, at the district level all the way up to the Supreme Court, and it's always the same outcome. At the district court, some judges say, I'm going to ask you point blank, do you recognize my jurisdiction? And if you say no, they'll throw you in contempt. It's as simple as that. I've seen it happen. Judges don't play that. District judges, which is the first level usually, I don't want to say the bottom, but it's the bottom, that's where you get started at. They don't put up with that. They have zero tolerance for that crap. You want to come out with a scroll and unroll it, with your powdered wig, talking about the writ of 1437 or something. They're not going to put up with that. They got to move it along. They got a busy docket. They might have 100 cases in a day. They don't have time for a sidebar. They don't have time to, debate the law with you. They'll just lock you up and that's it. So the reality of the matter is the sovereign citizen movement, whether they wanted it or not, got more airtime than they could ever dream of during this trial and looked as stupid could be. Because, their theories are nonsense. They're bunk. But the reality of the matter is DuhRel Brooks Jr. could have prevented all of this had he kept counsel. But his decision was to represent himself because, honestly, none of these lawyers, not the two that he had or any other public defender, would, parrot this sovereign citizen crap. They wouldn't do it. They just wouldn't do it. If they took their license seriously, they wouldn't do it. If they took their name and reputation seriously, they wouldn't do it. And that, I think, is the fundamental reason why he chose to represent himself. There was probably conversations, I don't know, it's attorney-client privilege, so we'll never know. But there was probably conversations between Duhrell and his public defenders where he was telling them, look, I want you to raise subject matter jurisdiction. I want you to ask where the plaintiff is. I want you to say that you're a third party, or that I'm a third party intervener, or that you're a third party intervener. And they probably looked him in the face and said, you're absolutely nuts. We're not going to say that. We're licensed practicing attorneys in good standing. We're not going to make fools out of ourselves. What you're saying amounts to nothing. It's hot air. And so probably after 3 or 4 or 5 of those conversations, DuhRel Brooks Jr. got tired of making the same points and said, you know what, I'm going to represent myself. I'm going to show you how it's done. And that he did. He showed the world that he's an idiot. You know what I mean? But so it's just funny, though, because, he always went to rush to judgment and always tried to say that some injustice was afoot, when the only injustice afoot was the fact that, well, it wasn't an injustice. It was the fact that he was going to get what he deserved. And he really didn't get what he deserved, but he got enough that I feel that justice was done. A lot of people, death penalty proponents, believe that, if there ever was a candidate for it, you know what I mean? But the reality of the matter is there's no death penalty that I'm aware of in Wisconsin. If there is, they didn't use it. And they gave him the rest of his life behind bars. And every day that he's deprived of his freedom will be a day that justice wins.